I believe, Chair, I'm taking the first round.
I'll pass my time over to Mr. Caputo.
Sorry, Mr. Caputo. Over to you.
Thank you. Glad you got my name right. Thank you to the witnesses for being here. Through you, Mr. Chair, I direct the following questions to the Minister. Minister, you were asked to appear and you refused, and yet you are here today. Why the change of heart?
So I'm very happy to be here. I'm glad to discuss this legislation with the legislative agenda that we've been moving forward with, including engagement with other parliamentary committees, making sure that we had the capacity to appear informed to discuss the matters. It's not a coincidence that I'm here days after we've tabled Bill C-16, the third piece of criminal justice legislation this fall. There's many priorities that we're trying to pursue simultaneously, and to make time for this committee is something that is a pleasure for me.
So to be clear, I mean, you've said it candidly, you blew off the committee until Bill C-16 was tabled.
No, I have a wildly different characterization. I would never blow off a committee. Ensuring that we have the opportunity to appear where my testimony is most relevant, where we have the opportunity to manage the workflow through government, and ensuring, keeping in mind that this bill is technically the responsibility of one of my colleagues who's already testified at this committee, making sure we can advance multiple priorities at once is really part of the reason for my appearance today.
The issue is, Minister, you declined to be here, and then you accepted. And you just said that coincided with Bill C-16 coming forward. Now, I'm not sure, as a Minister of the Crown, you should be prepared to be here at any point in time. And I don't think that gives Canadians reassurance when the Minister can pick and choose when they're coming in. With that being said, Minister, I'm not sure about you, but I believe you would probably agree with this, that we should be listening to the people on the ground. They're the ones who are going to tell us whether something's working or not, whether something is good or not. We can probably agree on that, like victims, things like that.
I think it's important that we engage to understand the perspective from many people who have experience in the system, who've been tasked specifically with identifying solutions to conduct investigations,
of course,
including people who have lived experience. And bringing those perspectives together to identify the best path forward is part of the role of governing.
And the role of government is to listen. So if we are going to listen to groups like victims and like the Association of Canadian Police Chiefs, the reality is the testimony that's been heard at this committee has been very clear. It's been unequivocal, in fact, from what I've been told, is that victims and the Canadian Association of Police Chiefs have said that victims should have the choice. They should have the choice whether to participate in an overburdened system that has repeatedly let them down or participate in the military justice system. But Bill C-11 denies them that right. Are you prepared to listen to victims, to listen to the Association of Canadian Police Chiefs and agree to that amendment?
Look, I want to understand their perspectives, but I also am cognizant of the fact that the former Supreme Court justice that we've had look into this more or less described this as a false choice because we see such a low level of reporting because of one system's existence that includes the fear of retribution, includes a history of failing victims, including potential interference within the chain of command, including the ability to share info with the military police throughout the process. A lot of people are making the choice not to come forward at all because of the personal consequences that might exist should they participate.
A lot of people are choosing not to come forward at all because of the last 10 years of failure when we have so few victims of sexual assault. And I was in the trenches for part of that time, and I can tell you how difficult it is for a victim to navigate the system. Sections 276 through 278 of the Criminal Code are very difficult as it is, and from what I understand, Minister, only one of the three justices said that there should be no choice. Victims want a choice. The police want the choice. The Provost Marshal General suggests a choice. The Director of Defense Counsel Services wants a choice. But despite all that, Minister, we all want victims to be represented. I have no doubt that you want that. So why aren't we just going to listen to victims in this case and give them the choice?
So this is an important conversation, and listening to victims has to be part of the process. But it's not lost on me that Justice Arbour, in coming up with her recommendation, worked with many victims who have experience as well, and their voice should also be listened to, and trying to figure out the best path forward, informed not only by the lived experience of some witnesses who very courageously share their perspective, but also listening to the experts who've talked to 1,000 witnesses or more, victims or more, to inform the recommendations that they've been tasked to provide is an important part of the process. And I think that's
let's get
part
into
of the
that, Minister.
path
You
of
talked
getting
about,
to the right
I
solution.
apologize for interrupting you. I do have
okay.
limited time. Justice Arbour said that, but Justices Fish and Deschamps, both of whom sat on the Supreme Court of Canada, said that victims should have the choice. So on the one hand, you're prepared to listen to Justice Arbour's recommendation, and obviously we respect and thank the work she's done on human rights and on this. But two other justices said, no, give them the choice. And this panel has consistently had people come and say, give victims the choice. So if you're going to hang your hat on Justice Arbour's position, how can you ignore the position of Justice Fish, the position of Justice Deschamps, and the people who've appeared here at this committee? Why are you preferring one to the other, Minister?
Well, in addition to the extensive engagement that Justice Arbour undertook to land on this particular recommendation, the reasons that she attached to her report are compelling. When I understand that there is the real fear of reprisal within a person's career, when I understand that there's potential for interference within the chain of command, when I understand that very sensitive personal information can be shared outside of that particular justice process, it gives me real cause for concern that, on balance, at the end of the day, continuing through this broken system is going to do harm to more people. There is no perfect solution that will solve the epidemic of gender-based or sexual violence that exists in Canada overnight, but I believe sincerely that this is a path in the right direction to ensure that justice prevails.
Thank you, Minister.
Thank you, Mr. Kluge.
For you, Mr. Chairman, to the Minister. So I never thought I'd hear the day the Liberals said they would deny a woman's right to choose. And they want choice in this matter. The concern is that the less egregious assaults will be they'll get away with it, and it just escalates over time. So have provisions been made so that the lesser assaults will be addressed fully within the military system, since they won't be addressed in the court system?
Just before, I don't think it's necessarily appropriate to be trying to meld together conversations about women's reproductive rights and the different court systems. And more broadly, I just find I find this point very important that I made it several times. I don't think it's a real choice that exists today. Justice Arbour's position on this explained that the so-called choice being presented to victims is one, if they go through the military justice system, is one that has a culture where there is very serious fears of reprisals, personal consequences that could come to the victim in their life and career outside of the criminal justice process, the potential for sensitive information to be shared about their assaults.
We've heard that from the witnesses themselves. So with that, recently we saw in the news that former General Denis Fortin was acquitted of what he was accused of. Had that taken place completely, if it had taken place in these actual civilian courts, he would not have the right to defense counsel, whereas the way it's handled now, they do. The people who are the accused are covered by military defense attorneys. So is there money going to be allocated to ensure that the people have the same rights and protection in having their court case defended as they do now through having the military defense counsel?
Look, I obviously can't comment on individual cases, but it would go through the civilian context. This is not a scenario where different governments cover the legal costs of defendants who find themselves before the court.
Actually, it is. But have you actually spoken or consulted with the Minister of National Defense prior to your introducing C-11 in the House?
We had spoken on a number of occasions, and actually on an ongoing basis, because it's not just C-11 that has concern for a common problem that we're trying.
C-11, because you know we all talk with each other, but did you specifically speak about C-11?
In combination with other bills, yes.
Okay, so why hasn't the Minister of National Defense asked for your input on this particular bill?
We're members of the same cabinet. We have input on each other's decisions in all instances.
Okay. Have you assessed the impact of moving the misconduct cases from the military justice system to the civilian court system, including the cost and the greater possibility that the cases are going to be thrown out because they just run out of time due to the Jordan decision?
So we have considered, and when you look at the comparative volume of in the range of 100 cases annually in the military context compared to tens of thousands of complaints that are made publicly in the civilian context, the incremental difference for the system is not great, although the impact on the individuals is obviously of a significant magnitude. On the issue of the impact on delays, that is a problem that we want to solve, and the reforms that have been included in Bill C-16, we have confidence will have a meaningful impact to both reduce the delays that people experience and change the outcome as a result of the Jordan decision.
So when you take away the choice of where the case is going to be tried, what happens is it is often a career decision when a woman decides whether or not she is going to take the case and have it go forward. So if they don't have that choice, it condemns a number of women to being kicked out of the forces because they actually spoke. Has that been taken into consideration? And if so, have you spoken to victims about this?
So that is a real phenomenon that is motivating part of the decision to move away from the military justice system for these kinds of cases. And it's our view that when you present people with a system where superior officers potentially have the opportunity to engage in the justice system, where you have information that can be shared that's very sensitive, that can be shared throughout the chain of command, it creates a culture where the exact phenomenon you're concerned about impacts people's life and career, and we think there's a better
Point
path.
of order. Mr. Speaker, Mr. Chair, for the sake of the interpretation, I'd ask that the member allow the minister to answer so I can actually hear the translation. Thank you.
Please proceed, Minister.
Oh, so, that was my answer.
With that, when they have the chain of evidence, we've heard several situations where the chain of evidence was the evidence was thrown out because they didn't trust the chain and that it was secure that all the way through. So, what in C-11 ensures that any investigation, initial contact with a victim, will be preserved in such a way that it won't be thrown out of court?
Well, you would be dealing with the protections that exist within the criminal justice system more broadly. You have the opportunity to have an independent investigation. You have the opportunity to have the independent crowns who are going to be laying charges, be moving through the criminal justice process. And that system, in my view, being separated from the military justice system, being separated from the military chain of command, has a greater degree of independence than currently exists within the military system today.
Still the transfer, and it's in the transfer of one system to the next where the evidence may be thrown out. So are there provisions in the bill to take care of that?
Yeah, but this who actually is going to be running the investigations will matter here. And when you have the ability to have the investigation to exist in an independent context, I have a greater degree of faith that the path forward will be an improvement in a civilian context. Than
Even if it happens in theater?
Well, there's a difference between what may happen inside of Canada and outside of Canada, and that is an area that may be helpful ground for this committee to study
exercise,
further.
Yeah.
Thank you. Mr. Chair, it's disappointing we're focusing so much on Bill C-16 and showcasing that before it's being debated and not C-11 and the particular instances of military sexual trauma. We've heard heartbreaking testimony from many victims, Minister, and survivors. Overwhelmingly, they have said they want choice. We've had the testimony of Justices Deschamps and Pish who say they support choice between the two military and civilian justice systems, and you only focus on Justice Arbour's report. I think that everybody's voices should be included. I think that all of those recommendations should be included and not just cherry picking. Victims have said overwhelmingly they will not bring many of their cases forward to civilian courts, including the low-level ones. In fact, many of them have reported that their cases have been turned away from the civilian system. Why will you not hear their voices of everyone, hear the majority of voices? And why do you insist on taking away choice so that victims can choose? And this is military sexual trauma, which is very different than just sexual trauma. Why do you insist on taking away that choice from them between those two systems?
So, very respectfully, I have a sincerely held different view. The choice that I see playing out right now in the military context is for so many people not to come forward at all. It's for the reasons that I've outlined. Mr. Chair, do I have time to offer a response similar to the length of the question?
This isn't about your view. This is about the view of victims of military sexual trauma. And we've had
Mr. Chair, do I have an opportunity to offer responses?
My apologies, Chair, but interpreters cannot do the work that they need to do when we have two people talking over each other.
Mr. Kibble, I'll give you a few extra minutes, but I'll let the Minister respond, please.
Thank you, Mr. Chair.
On this issue, my view is informed by the reports that have engaged 1,000 victims or more. My conclusion is that there are many, many people who are choosing not to come forward for the reasons that I've articulated previously in this session. That includes the fear of reprisals. It includes a lack of independence when you have actors in the justice system who are subject to the chain of command. There are very real consequences to a person's life and a career that's causing them not to come forward. When we see 100 cases nationally in that ballpark coming forward, I expect that there's a significant number that go unreported compared to the tens of thousands that we see reported across the country in a civilian context. I'm not arguing one system is perfect. I think there is a better path than exists today.
Thank you, and I appreciate that, but this shouldn't be about your view of this. This should be about the view of the victims, and I appreciate you've heard from thousands of victims, and overwhelmingly they have supported choice. I've also, earlier in your testimony, I was glad to hear that you said that civilian police have appropriate training in dealing with sexual assault. I think that's very important, and that they're trauma-informed, and you acknowledge that. However, military sexual trauma is very different. Police, including the Victoria Police Chief, have said that police services, and they deal with multiple, the potential to deal with the cases at CFB Esquimalt, second largest base in Canada. Victoria Police Chief has said that they would need specialized training in dealing with military sexual trauma, that they would need funding to support the extra work that they do not have the capability to deal with. These are hundreds of cases potentially that are coming. Will the government give them support, ensure that they have the training dealing with military sexual trauma and its differences, dealing with different evidence handling, records, personal records, and access to information? Thank you.
Thank you. So we do have programs that support this kind of training through the Victims Fund. Whether there will be an application forthcoming, I'm not aware of that. But that is an opportunity for us to actually work to ensure that there is appropriate level of training for people who understand the unique context. And I accept the context would be different in a military context.
So thank you that there's a training available. But I'm speaking specifically of funding in the millions of dollars that civilian police forces and provincial justice systems are going to need to take on this extra load and this extra training. Will the government provide those millions of dollars, or have you even considered or asked anybody about that extra load and training and dollars that will be needed to support this just being thrown onto the civilian justice system?
Well, the creation of the Victims Fund was partially motivated by the need to address these very specific kinds of things, because we're seeing specialized courts pop up in different parts of the country to address these kinds of concerns. We don't obviously have a funding announcement to make at this parliamentary committee hearing, because we would require an application to come in, to be assessed, to actually work with the proponent who would be seeking to tap into these federal funding opportunities. So there are funding opportunities there, to answer your question directly. Whether we have a specific one in Victoria for the local police force or court systems would depend on engagements that would need to take place in advance of funding applications.
Mr. Anderson, thank you. I know that you added some.
Yeah, it's expired. Okay,
So
well, go, Mr. Anderson, go ahead. Go ahead.
Thank
Want
you.
to ask one question?
Well, I don't have one question. I've got a bunch of questions.
No, we'll have to wait for your time if that's the case. Mr. Anderson, back to you now.
Oh, good. Thank you, Minister. Do you have any military experience?
No, I've not served in the military.
Okay. Do you understand the difference between chain of command and the military prosecution system?
I know that those are distinct concepts, but in this instance, there could be interplay.
Well, not really. You've used the term within the chain of command, interference within the chain of command. How do you understand the chain of command, the relationship?
In general terms?
In general terms.
That you would have a reporting officer that you would take orders from, and they may have a officer superior to them, and so on.
And what is the relationship to the military justice system?
Well, there is potential for information
No,
sharing.
not
that could
potential.
take
What
place.
is the relationship between the two?
So my concern is not just.
No, but I'm asking you what the relationship, what your understanding of the relationship is between the chain of command and the military justice system.
Though there are distinctions, my concern is that there is information that can bleed between one and the next, and that the folks who act within the chain of command could have reprisals come to the individual who makes a complaint within the military justice system.
Okay. Well, that's extremely tenuous given the relationship between the two of them. Are you aware that each case transferred to the civilian system has hundreds of hours of investigatory hours attached to it?
It would depend on the specifics of the individual case, but it would be possible, certainly, depending on how far advanced the investigation is.
We're transferring 100 cases there, it's as if it's nothing compared to the tens of thousands. It actually is. It's if you do the math, it's...
I don't want to be understood to say that it's nothing. Every one of those cases is a big deal and is very meaningful, particularly to the individuals involved. The comparative volume is a factor that we should consider.
And you have heard the Chief of Police of Victoria saying that they simply can't handle this without any resources.
And I think that we would need to understand how to make sure that the civilian system is equipped to handle these, but some of the changes that we're making will
Make sure
improve
by
that.
transferring money to them?
Potentially through the training programs that I've discussed at this committee earlier,
Okay,
but
but it's
also
not-
by changing the processes to speed up the process of getting through trial and to avoid the consequences of stays for delay.
Okay, I want to return to choice here. The idea that removing choice is a benefit to the victim, that to me seems to be one of the most paternalistic, almost mansplaining, that we shouldn't have a choice, in spite of the fact that every victim, that except for one that has turned up here, has said that they prefer a choice, that they would feel much more secure having a choice, that there are many incidences in which they may want to remain within the system. Furthermore, we heard testimony from the military justice system itself, both the prosecution and the defense and the Provost Marshal, that they have the capacity, that the culture has changed over the past 5 years or 10 years, that they are significantly more ready to prosecute these things in the military, if necessary, if the victim chooses to do that. I cannot think of a good, we seem to be going around in circles. You're giving us all sorts of reasons why you feel that this, in spite of the evidence and in spite of the testimony, are you prepared to maybe make a choice if you re-examine the evidence that victims should have a choice? Is that open in your mind at all, or is this a closed book?
So the evidence that we've reviewed includes the report that was commissioned for the specific purpose of
Several
addressing this
reports,
challenge.
many of which have thousands of victims. That's not the question. Are you prepared to contemplate putting choice back into this bill?
My point of view, informed by the reports that were commissioned to address this issue, is that the system will be improved on the whole if we move the sexual offenses into a civilian context.
You intend to remove choice?
There is a false choice that exists. You continue to say
No, sir, there is
choice.
not a false choice.
The choice so many people are making right now is not to come forward because they do not believe it will result in justice. They believe that they will be re-traumatized.
Tell me what happens then, because nobody else can seem to answer this. On a low level thing, we've removed jurisdiction from the military for sexual assault. Is that correct? In C11? It says that we have.
Yeah, I understand what you're saying. There's some unique context around the interim directive and the process that continues to exist today, but...
That's correct. Yeah. And so a low-level thing, a pat on the bum, is not going to be prosecuted. Yeah, we've got that definitely from one of the justices that appeared here. 2 pats on the bum probably won't be prosecuted as a criminal offense. What does the victim do? How are you planning to change the culture in the military if all of the low-level stuff is simply ignored because the military doesn't have jurisdiction to deal with it?
Well, I still think that it's important that you maintain a complaints process. To
who?
Well, it will depend on the context. Sometimes if there's a serious sexual assault, it could be a full-blown prosecution.
Sorry, we're going to be wrapping up soon.